All right, welcome back. Got kind of a good news, bad news stream tonight. So, eh, yeah, it's going to be shorter on the bright side than yesterday's marathon of a stream. But today we're returning to Idaho for Scofield versus Guillard, the Tic Toc psychic defamation case. So, last time we were here was mid March. And if you recall, basically, Professor Schofield had entered, applied for a default judgment against the psychic and had trouble getting it served on the psychic because she refused to accept the mail. And I said, if like the judge was gracious enough not to enter the default judgment in the first place. But I said, you play these games, you just make it all the more likely. Well, on, let's see, the 19th, we had a fun new entry. And this was a month and 5 days and 31 days in March. So that's 36 days after notice that the psychic had finally accepted service of that document. Well, 36 days, for those of you who are math challenged, is longer than the 21 days that are allowed for a response. So after the 36 days, Professor Scofield gave the court notice. Basically, we've got this document. It's what was it? It's docket number 16, filed on the 19th. And it's notice of defendant's failure to comply with local rule 7.1. Local rule 7.1, of course, being the rule in accordance with Federal Rule of Civil Procedure 12, giving 21 days to respond to motions that require a responsive pleading. So, getting into the body of the notice, on January 27th, 2023, the clerk of the court filed an entry of default because defendant Ashley Guillard failed to timely respond to plaintiff Rebecca Scofield's complaint, ECF 5. Several weeks later, Guillard attempted to file a motion for relief and an untimely answer, which included improper counterclaims, in quotation marks, against Professor Scofield's attorneys, ECF 6 and 7. In the motion for relief, Guillard wrote, "Going forward, Ashley Guillard will prioritize court rules, orders, and actions and file timely actions." ECF 7, page 6. Guillard has not honored her representation to the court. Since Guillard represented that she will file timely actions, Professor Scofield has opposed Guillard's motion for relief and filed a motion for default judgment and a motion to strike, ECFs 10 and 12. The deadlines for Guillard to file her responsive briefing have long passed by 15 days at the time this was filed. Guillard has thus failed to comply with Local Rule 7.1. That failure may be deemed to constitute a consent to the sustaining of said pleading or the granting of said motion or other application. Local Rule 7.1E1. That is, Guillard's failure to submit timely briefing provides an additional reason why the court should deny her motion for relief, ECF 7, and grant Professor Scofield's motion for default judgment, ECF 10, and motion to strike, ECF 12. Dated April 19th, 2023. Signed Wendy J. Olson and her other attorneys, attorneys for plaintiff, April 19th. And served by email, although that's going to change for reasons. So that was short and sweet and to the point. After yesterday's video, that's refreshing. So then we have, let's see, I don't know that I needed to, this is longer than I expected, but that's okay. So that was a preview of docket 18, the memorandum, decision, and order, which I'm just going to first read it off the docket. So frankly, I'm surprised. I thought, you know, up through docket number 17, you look at the totality of the misfeasance and missed deadlines and the just completely ignoring deadlines and refusing service of motions. If there's ever any case where you'd think, yeah, a default judgment is going to be entered, you'd think this would be it. But this shows just how strongly judges prefer for their decisions to be on the merits instead of a technicality, a rule violation. They want it on the merits, whether that's for the plaintiff or against them. They want to dismiss on the merits. They want to have a judgment for the plaintiff on the merits. On the merits. So the memorandum, decision, and order from the docket. Defendant's motion to set aside entry of default is granted. So that's docket number 7. Plaintiff's motion for default judgment, docket 10, is denied as moot since they granted 7. Defendant's motion for CM ECF access, docket 8, is granted. And then just defendant shall immediately contact the clerk to set up ECF access. Plaintiff's motion to strike, docket 12, is granted. Let's see. Okay, it's so motion to strike, docket 12, which is motion to strike 6, the answer to complaint counterclaim. So basically the motion to strike, I'm assuming, is saying, yeah, you can't sue the attorneys. And then defendant shall formally respond to plaintiff's complaint within 21 days of this memorandum, decision, and order, unless otherwise ordered by the court. Signed, Judge Raymond Edward Patricio, Jr. So basically, that was April 26th. So 21 days May 27th, or May 17th, sorry. I can't math either. We should expect a response. Well, except if, well, maybe the whole answer has been stricken, not just, and so ordering a whole new answer. Well, instead of guessing, let's actually read that docket entry, the entire ruling. So, pending before the court are 4 interrelated motions. 1, defendant's motion for relief from a judgment or order pursuant to Rule 60B, motion to set aside entry of default, docket 7. 2, defendant's motion to be granted ECF access pursuant to local rules, docket 8. 3, plaintiff's motion for default judgment, docket 10. And 4, plaintiff's motion to strike defendant's answer, affirmative defenses, and counterclaims to complaint, motion to strike, docket 12. In the interest of avoiding delay, and because the court conclusively finds the decisional process would not be significantly aided by oral argument, these motions will be decided on the record and without oral argument. As discussed more fully below, the court will grant defendant's motion to set aside entry of default, rendering plaintiff's motion for default judgment moot. The court will also grant defendant's motion for CM ECF access and plaintiff's motion to strike with leave to refile defendant's responsive pleading. Background. This case arises out of the tragic murder of 4 University of Idaho students in November 2022. Plaintiff Rebecca Scofield is a professor at the University of Idaho. She alleges that, despite never meeting the students or being involved with their murders in any way, defendant Ashley Guillard posted sensational Tic Toc videos falsely claiming that plaintiff had an inappropriate romantic affair with one of them and then ordered the murders. In turn, plaintiff brings 2 defamation claims against defendant, one premised upon false statements regarding plaintiff's involvement with the murders themselves, the other premised upon false statements regarding plaintiff's romantic relationship with one of the murdered students. Relevant to the at-issue motions, plaintiff filed her complaint on December 21st, 2022. 6 days later, defendant was personally served in Houston, Texas. Defendant never responded to plaintiff's complaint by the January 17th deadline. See Federal Rule of Civil Procedure 12A1A1. A defendant must serve an answer within 21 days after being served with the summons and complaint. As a result, pursuant to Rule 55A, plaintiff moved for an entry of default on January 19th, 2023. A clerk's entry of default was then entered and mailed to defendant on January 27th, 2023. On February 16th, 2023, defendant filed her motion to set aside entry of default, apparently anticipating that the entry of default would be set aside. Defendant also filed her answer, affirmative defenses, and counterclaims, alongside her motion for CM ECF access. Plaintiff responded the next day, opposing defendant's efforts to set aside the entry of default and filing a motion for default judgment pursuant to Rule 55B2. Plaintiff's motion to strike followed on February 27th, 2023. Each of the pending motions is ripe for the court's consideration and resolved below. Analysis. Defendant's motion to set aside entry of default and plaintiff's motion for default judgment. Legal standard. The court may set aside an entry of default for good cause, and it may set aside a final judgment under Rule 60B, Federal Rule of Civil Procedure 55C. An entry of default is a technical formality. A plaintiff must merely show, by affidavit or otherwise, that a party against whom a judgment for affirmative relief is sought has failed to plead or otherwise defend, upon which showing the clerk must enter the party's default. Federal Rule of Civil Procedure 55A. Therefore, setting aside an entry of default under Rule 55C is simpler and more straightforward than setting aside a default judgment under Rule 60B. See US v. signed personal check number 730 of Ubron S. Measle from the Ninth Circuit in 2010. In the Rule 55 context, there is no interest in the finality of the judgment with which to contend. Federal Rule of Civil Procedure 55, advanced commentary note in the 2015 amendment, the demanding standards set by Rule 60B apply only in seeking relief from a final judgment. So basically, the court's saying, the clerk's entry of default was ministerial. It was required, but it involved no analysis other than, hey, it's past the date to respond. You're in default. Whereas the Rule 60B default judgment actually takes legal analysis and figuring out what's owed, how much is owed if it's not a sum certain, like if it's not from a contract that says you'd owe this much. So if you get to that 60B default judgment, which is what Professor Scofield had applied for, then the court's less likely to set that aside because, hey, a lot of work has gone into deciding that. Whereas the Rule 55C entry of default, you just uncheck the box, basically. It's easy. Whether to set aside an entry of default is a matter of discretion. In re Bernal from the BAP Ninth Circuit, 1998. See also Wright, Miller, and Kane, Federal Practice and Procedure, 3rd edition, section 2694. The different treatment in Rule 55C of the default entry and default judgment frees a court considering a motion to set aside a default entry from the restraints of Rule 60B and entrusts the determination to the discretion of the court. In determining whether good cause exists to set aside an entry of default, a court must consider 3 factors. 1, whether the defendant engaged in culpable conduct that led to the default. 2, whether the defendant had no meritorious defense. Or 3, whether setting aside the entry of default would prejudice the opposing party. Citing, once again, Measle. The standard is disjunctive, meaning it has an or in the list instead of and. So the standard is disjunctive, such that a finding that any one of these factors is true is sufficient reason for a court to refuse to set aside an entry of default. The defendant, as the party seeking relief from the entry of default, bears the burden of showing that these factors favor such relief. Citing Franchise Holding v. Huntington Restaurant Group, 9th Circuit, 2004. Crucially, however, judgment by default is a drastic step appropriate only in extreme circumstances. A case should, whenever possible, be decided on the merits. Once again, citing Measle. Good cause exists to set aside the January 27th, 2023 clerk's entry of default. Section A, culpable conduct. There are two lines of cases within the Ninth Circuit regarding the standard for culpable conduct, citing Rafferty versus Key Point Government Souls Inc., District of Idaho, 2016, which cited Garner versus Wells Fargo Home Mortgage, also District of Idaho, 2011. One line of cases holds that a defendant's conduct is culpable if she has received actual or constructive notice of the filing of the action and intentionally failed to answer, citing TCI Group Life Insurance Plan versus Nober, Ninth Circuit 2001, which quoted Allen Newman Products versus Albright, Ninth Circuit 1988. In this context, the term intentionally means that a movement cannot be treated as culpable simply for having made a conscious choice not to answer. Rather, to treat a failure to answer as culpable, the movement must have acted with bad faith, such as an intention to take advantage of the opposing party, interfere with judicial decision making, or otherwise manipulate the legal process. Once again, citing Measle. Courts have typically held that a defendant's conduct was culpable for purposes of the good cause factors when there is no explanation of the default inconsistent with a devious, deliberate, willful, or bad faith failure to respond. A second line of cases suggests that if a defendant has received actual or constructive notice of an action and fails to answer, that conduct alone indicates culpability, citing Rafferty, which cited Franchise Holding, Direct Mail Specialists Inc. From the Ninth Circuit. Application of this more lenient standard for finding culpability hinges on the legal sophistication of the defendant, citing Measle once again, holding that it is possible to reconcile the language in Franchise Holding 2 with the standard in TCI Group when considering a legally sophisticated party's culpability in a default and understanding of the consequences of its actions may be assumed, and with it, intentionality. So basically, a lawyer would be held to the second standard, or maybe a represented party reaches this standard, or, if you're suing a law firm, or if you're suing a massive corporation that has an in-house legal team, I don't know exactly where the line is drawn, but Tic Toc Psychic probably doesn't qualify as legally sophisticated. Here, the defendant is representing herself pro se and is not a lawyer. So, the TCI Group standard applies, citing Measle again. It is sufficient to observe that Measle is not a lawyer and that he was unrepresented at the time of the default. Accordingly, the proper standard to apply was that of TCI Group. The defendant's explanation for failing to timely respond to plaintiff's complaint is that she has been so overwhelmed with multiple civil actions and responsibilities. Defendant's memo to set aside the entry of default. Defendant specifically references how she, one, is contemporaneously representing herself pro se in a Texas state court of action. Two, is the custodial parent to a child whose father is away on military orders. Three, is the local next of kin to a family member who is in the hospital and on life support. Four, recently feared for her and her family's safety following multiple attempts by someone trying to enter her apartment illegally. 5, suffers from emotional distress as a result of plaintiff's claims against her. And 6, suffers from combat-related post-traumatic stress disorder, which impacts her ability to finish tasks when under stress. According to defendant, these circumstances collectively diminished her ability to efficiently handle all the responsibilities, including timely responding to plaintiff's complaint. The court takes no position on the genuineness of these claims, but acknowledges plaintiff's counterargument thereto that defendant continued her publicity-seeking commentary about plaintiff's alleged involvement with the murders even after being served with plaintiff's complaint. The reality is, defendant spent her time posting at least 100 videos on TikTok, writing 3 blog posts, talking to reporters, recording a 40-minute YouTube video, and interacting with viewers in the comments section. If she had spent that time putting those defenses into an answer instead of posting online to get more clicks, she could have filed a timely response. It is a quote from plaintiff's motion to set aside. And footnote 1. The court has reviewed the available postings referenced in plaintiff's briefing. Though off-putting and ill-advised, they reflect defendant's intention to defend the case. So the court has watched the TikTok videos that have been linked. Instead, the court accepts defendant's account for the limited purposes presented here. C.e.g. Gargoyle Granite and Marble Inc. versus Opustone, District of Idaho 2022. On a Rule 60B motion to vacate a default judgment, this court will accept the allegations of the movement's factual statement. In the less strict Rule 55C posture, therefore, this court will do likewise. Doing so reveals that defendant's admitted failure to timely respond to plaintiff's complaint was most likely an unintentional oversight caused by self-serving carelessness, explained by defendant's pro se status, and confirmed by her relatively prompt attempt to set aside the clerk's entry of default once alerted to it. Footnote 2. The court mailed a copy of the clerk's entry of default to defendant on January 27, 2023. Defendant, however, states that she was only made aware of plaintiff's motion for entry of default on February 10, 2023, in a telephone call with court staff. Defendant's memo seeking to set aside the entry of default. Defendant then mailed her motion to set aside entry of default on or around February 14th of 2023. To the extent defendant complains that she was not originally served with plaintiff's motion for entry of default, she is incorrect. Rule 5 provides an explicit exception to the service requirement in such instances. No service is required on a party who is in default for failing to appear. Federal Rule of Civil Procedure 5A2. Although the court does not condone such conduct, footnote 3, defendant represents that, going forward, she will prioritize court rules, orders, and actions and file timely actions. The court intends to keep defendant to her word. So, although the court does not condone such conduct, without more, it does not amount to bad faith with an intention to take advantage of the opposing party, interfere with the judicial decision-making, or otherwise manipulate the legal process. As a result, it cannot be said that defendant engaged in culpable conduct that led to her default. This factor, therefore, weighs in favor of setting aside the entry of default judgment. Meritorious defense. A party seeking to set aside entry of default must present specific facts that would constitute a defense. But that burden is not extraordinarily heavy. Quoting Measle, which notes, the minimal nature of the burden that the moving party is supposed to carry. All that is necessary to satisfy the various defense requirement is to allege sufficient facts that, if true, would constitute a defense. The question whether the factual allegation is true is not be determined by the court when it decides the motion to set aside the default. Rather, that question would be the subject of the later litigation. Here, the very nature of plaintiff's claims against defendant presumes the existence of certain possible defenses. That is, to prevail on a defamation claim in Idaho, a plaintiff must prove that, 1, the defendant communicated information concerning the plaintiff to others, 2, the information was defamatory, and 3, the plaintiff was damaged because of the communication. Spokesman Review, Idaho 2007. But truthful statements and personal opinions in certain situations are not defamatory in the first instance. People need to be careful because they often say outrageous things and say, in my opinion, as if that's a cure-all for defamation. It's not. It can help. It can weigh things in your favor, but it's not necessarily a cure-all. Defendant, unsurprisingly, takes this position in her proposed answer, affirmative defenses and counterclaims. There, defendant generally submits that plaintiff's complaint fails to state a claim upon which relief can be granted, while also indicating that her allegedly defamatory statements are true or otherwise not actionable. Importantly, defendant need not conclusively establish the validity of these defenses right now. At this stage of the proceedings, the court only determines whether defendant has alleged defenses that, if true, should be decided on the merits. Again, not whether those defenses are once and for all meritorious as a matter of law. Just that they could be true. On this record, the court finds that defendant has satisfied the meritorious defense requirement, keeping in the mind the admonition that a case should, whenever possible, be decided on the merits. This factor, therefore, weighs in favor of setting aside the entry of default. Prejudice to plaintiff. Sorry. Spring has just refused to come to Utah this year, despite it being the end of April. And I forgot to plug in my laptop, so pardon the commotion while I do that so that I don't disappear on you. But yeah, so spring is finally arriving. The fruit trees are finally blossoming, and I was outside today in that, so it hit me with a little allergies just because I'm not used to it yet. Hence the sniffles. So, prejudice to plaintiff. To be prejudicial, the setting aside of an entry of default must hinder a plaintiff's ability to pursue her claim. Citing TCI Group. Delay alone is not enough. To be prejudicial, the setting aside must result in greater harm than simply delaying resolution of the case or being forced to litigate on the merits. Prejudicial delay must result in tangible harm such as loss of evidence, increased difficulties of discovery, or greater opportunity for fraud or collusion. Quoting Thompson versus American Home Assurance Company, 6th Circuit, 1996. So that doesn't need much more explanation, but time alone is not prejudice. It's you know, if Professor Scofield planned to call Brian Koberger as a witness, but he was being, you know, put on death row next week, then it would prejudice her not being able to access him for his testimony. Stuff like that, you know, or if evidence is transitory in nature, if she's afraid Tic Toc is going to permanently delete the videos that she hasn't saved. That could be prejudice. Plaintiff states that she has suffered enough harm from defendant's antics, deserves the finality of defendant's decision not to assert timely defenses, and expresses frustration over defendant's disregard for procedure and deadlines. These are understandable reactions under the circumstances, but plaintiff does not actually explain how she would be hindered if the entry of default were set aside. To be sure, other than now being forced to litigate the merits, there is no prejudice, especially when the action remains positioned in the very early stages of litigation. This factor therefore weighs in favor of setting aside the entry of default. Having found that, 1, defendant has not engaged in culpable conduct that led to her default, 2, defendant has alleged meritorious defenses, and 3, setting aside the entry of default would not prejudice plaintiff, good cause exists pursuant to Rule 55C to set aside the January 27th, 2023 clerk's entry of default. Accordingly, defendant's motion to set aside entry of default is granted. Because the January 27th, 2023 clerk's entry of default is set aside, there is no basis for a default judgment. A clerk's entry of default against a party is the first of 2 steps required to seek an enforceable default judgment against the party that failed to plead or respond. The entry of default must be distinguished from a default judgment. Rule 55 requires a 2-step process. The first step, entry of default, is a ministerial matter performed by the clerk and is a prerequisite to a later default judgment. Because the court has set aside the January 27th, 2023 clerk's entry of default against defendant, it accordingly denies plaintiff's motion for default judgment as moot. Citing Super Mario Plumbing versus Beladidov. That's an excellent name, Beladidov. Defendant's motion for CM-ECF access. Defendant requests access to the court's case management and electronic case files, CM-ECF, program for the purposes of this action. Defendant's motion for CM-ECF access at 2, plaintiff does not oppose defendant's request. Therefore, for good cause appearing, defendant's motion for CM-ECF access is granted. Defendant is permitted to enroll as a registered participant in the electronic filing system solely for the purposes of this action. Defendant is ordered to follow all applicable procedures for electronic case filing, including but not limited to the District of Idaho's local civil rules and electronic case filing procedures. Permission to file electronically may be revoked for failure to do so. So she can't turn away the mail anymore because now she's just going to be served electronically through the CM-ECF system. Plaintiff's motion to strike, docket 12. Following the January 27th, 2023 clerk's entry of default, defendant filed her answer, affirmative defenses and counterclaim, docket 6, on February 16th, 2023, alongside her motion to set aside entry of default and motion for CM-ECF access. Plaintiff moves to strike these pleadings as both untimely and procedurally improper because the clerk entry of default had not been set aside. Plaintiff's motion to strike at 1 and 2. As stated above, the court cannot accept and consider defendant's pleadings because they were filed after the clerk's entry of default. see Great American Insurance Company versus MJ Menefee Construction Inc., Eastern District of California, 2006, which notes that entry of default cuts off a defendant's right to appear in the action. Plaintiff's motion to strike is therefore granted, and defendants answer affirmative defenses and counterclaims are stricken. Footnote 5. In a hyper-technical sense, defendant's motion for CM ECF access arguably should be rejected for the same reasons. But considering the unopposed nature of the relief sought therein, coupled with Rule 1's direction to construe and administer the rules to secure the just, speedy, and inexpensive determination of every action and proceeding, allowing defendant to utilize the court's CM ECF program makes practical sense given its procedural rather than substantive implications. Excuse me. With the clerk's entry of default now set aside, defendant shall formally respond to plaintiff's complaint within 21 days of this memorandum, decision, and order. And the order. Based on the foregoing, it is hereby ordered that 1. Defendant's motion to set aside entry of default is granted. Plaintiff's motion for default judgment is denied as moot. 3. Defendant's motion for CM ECF access is granted, and they need to follow the rules. And 4. Plaintiff's motion to strike, docket 12, is granted. Defendant shall formally respond to plaintiff's complaint within 21 days of this memorandum, decision, and order, unless otherwise ordered by the court. Dated April 26th, 2023, and signed by Honorable Raymond E. Patrico, or however, Chief U.S. Magistrate Judge for the District of Idaho, with a fancy seal. So, I guess that explains everything. It explains that it wasn't just the inappropriate counterclaims that were struck, but whole thing. So, within 21 days, I think I said by May 17th, we should have a new answer, which we'll see how much it differs from the old answer. And with that, well, like I said, it's good news, bad news, because it's bad news that Professor Scofield isn't getting her relief. Although I do, for the most part, agree with the court's reasoning. It's frustrating when it's such an egregious case, but I still agree with the court. But the good news is more entertainment for us, unfortunately at Professor Scofield's expense, but fortunately at Ashley Guillard's expense. So with that, do all the YouTube-y things on your way out. Like, share, subscribe, bribe your friends to do the same, and I will see you real soon for the next one. Thanks for joining me. Bye-bye.